Hello friends, my name is Amit Jyoti. I am Assistant Professor at the O.P. Jindal Global University. In the second module, we shall be discussing the historical events that led to the advent of human rights. This shall be divided into two parts. Now we will be discussing part 1. Today we understand human rights as rights that all people have by virtue of being human beings. The rights that are universal, inalienable and equal and cannot be taken away. And the rights that ensure that we all are entitled to a basic minimum things. The roots of these concepts lie in the earlier traditions of many cultures and documents produced by various nations and organizations over a few centuries. The first event, the Cyrus the Great Cylinder. In 539 BC, the armies of Cyrus the Great, the first king of ancient Persia, conquered the city of Babylon. He then freed the slaves, declared that all people had the right to choose their own religion, and established racial equality. These decrees were recorded on a baked clay cylinder in the Akkadian language with cuneiform script. The Cyrus the Great Cylinder is the first charter of human rights of nations in the World Charter. It was excavated in 1879 by archaeologist Rassam in the foundations of Marduk Temple of Babylon. It is currently placed in the British Museum, London at United Kingdom. The main decrees in the Cyrus Cylinder relate to the political formalization of racial, linguistic and religious equality. Slaves and all deported peoples were to be allowed to return to home, and all destroyed temples were to be restored. Cyrus the Great is considered to be an epitome of great humanistic qualities and for his generous and humane policies. United Kingdom and the evolution of human rights is the next part under this module. The first subpart here is Magna Carta. Magna Carta means the Great Charter. In 1215, after King John of England lost a battle against French in the northern France, it resulted into violation of a number of ancient laws and customs by which England had been governed. Thereafter, a peace deal was signed between the king and its people on the river Thames at a place Runnymede near Windsor in the south of England in June 1215. It served as a practical solution to the political crisis faced by King John I. This was known as Magna Carta. It is for the first time made the king subject to law like other citizens. Magna Carta originally provided for 63 clauses that enumerated the right of the church to be free from governmental interference, protection from excessive taxes, among others. But shortly after its adoption, the questions emerged over its implementation. This again led to a strained relationship between King John and people. After King John's death in 1216, when King Henry succeeded to the throne, he issued a revised version of the Magna Carta. In 1225, Henry III reissued a much revised version of Magna Carta, which was later enrolled on the statute book by King Edward I. It is believed the United States Bill of Rights 1791, the Universal Declaration of Human Rights 1948, and the European Convention on Human Rights 1950 echo the principles that were in fact laid down in Magna Carta. Even though most clauses in Magna Carta stand repealed today, yet it holds significance for the democratic setup in England and serves in situations where the state exercises arbitrary and tyrannical power against its nationals. The next event is the English Bill of Rights 1689. In the Revolution of 1688, when King James II fled the country and his daughter and her husband had to succeed, they had to agree to accept the Bill of Rights. The English Bill of Rights was passed by the British Parliament on December 16, 1689. The Bill of Rights covered the most important concern of its time, which is making the king subject to the rule of law like any other citizen. It contains restrictions on non-parliamentary taxation, no imprisonment without case, and the use of martial law. It basically established the parliamentary sovereignty and limited the constitutional monarchy. Each act by the king and the queen had to be approved by the parliament so that the rights and liberties of the citizens could be upheld in all situations. This bill had a massive impact on the North America and the US Constitution, which will be briefly discussed in a short while. Next, we will look at the historical evolution of human rights in the United States of America. The first document being the United States Declaration of Independence 1776. This declaration was adopted by the Congress on July 4, 1776, declaring independence of 13 British colonies and their formulation to the United States of America. Since this document originated out of the experience of the United States under the brutal rule of King George III, it had justified its independence by asserting various natural and legal rights. Philosophically, the declaration stressed on two themes: one, individual rights, and two, the right of revolution. It stated that the Creator has endowed all men with certain unalienable rights of life, liberty, and a pursuit of happiness. To secure these rights, governments are instituted among men. It also provided that whenever any government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government. Prudence indeed will dictate that governments long established should not be changed for light and transient clauses. But unfortunately, it did not extend human rights to all human beings. It preserved the institution of slavery and did not grant equal rights to women and men who were not white. In fact, the drafter of this declaration, Thomas Jefferson, himself is said to have held hundreds of slaves. The next document, the Constitution of United States 1787, along with the Bill of Rights, written in 1797, the US Constitution is the oldest written constitutions in use. It serves as the foundations of the US federal system and defines the principal organs of the government, their jurisdictions, and the basic rights of the citizens. The first 10 amendments to the Constitution are called the Bill of Rights. The Bill of Rights came into effect on December 15, 1791. It explicitly protects the rights not incorporated in the Constitution and limited the rights of the federal government. The Bill of Rights protects freedom of speech, freedom of religion, the right to keep and bear arms, the freedom of assembly, and the freedom to petition. It also prohibits unreasonable search and seizure, cruel and unusual punishment, and compels self-incrimination. The bill prohibits Congress from making any law respecting establishment of religion and prohibits the federal government from depriving any person of life, liberty or property without the due process of law. Since its inception, the Bill of Rights has contributed significantly in the development of human rights law in the United States of America. To further understand the development of human rights law in the United States of America, let's look at the three landmark cases that have been decided by the United States Supreme Court. The first, Dred Scott versus John Stanford of 1857. Dred Scott was a Negro slave belonging to Dr. Emerson, who was a surgeon in the US Army. Originally, Dr. Emerson was posted in the state of Missouri, a slave state at that time. Scott used to stay with him there. Thereafter, Dr. Emerson moved to the state of Illinois, which was a free state then. Scott stayed with him there as well. Thereafter, Dr. Emerson moved Scott to Upper Louisiana, a territory acquired by US from France, also a free state at that time. In 1835, Dr. Emerson bought another slave named Harriet. Harriet and Scott got married in 1836 with due permissions. In 1838, Dr. Emerson moved Scott and Harriet to the state of Missouri once again. Dr. Emerson sold Scott and Harriet to the defendant in this case, who moved to New York at some point in time. Scott sued the defendant for his freedom. He alleged that given that he has now traveled to a free state, he should now be a free man. In the Missouri Circuit Court of St. Louis County, the jury decided that Dred Scott and his family were free. Sanford, who is the defendant, appealed to a higher state court, which is Missouri Supreme Court, which reversed the decision and held that Dred Scott and his family were not free. Thereafter, Sanford moved to New York, leaving Scott and his wife in Missouri. Scott was able to sue Sanford in federal court as a new case where the jury decided that Scott and his family were in fact not free. Finally, Scott appealed to the Supreme Court. Now, the primary question before the US Supreme Court was, can a Negro whose ancestors have imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States of America, and as such become entitled to all the rights and privileges and immunities which are guaranteed by that instrument to the citizen? The court found in favor of Sanford and declared that the African Americans are not citizens and thus they have no rights under the Constitution. It was held that the term in the Constitution, "we the people of the United States," does not include Negroes. The framers did not have these people in mind as they were considered a lower class. They were, in fact, regarded as beings of an inferior order which were altogether unfit to associate with the white race. They were treated as an article of merchandise and traffic. Therefore, the discussion in the case on jurisdiction treats Negroes as a property and on the basis decides that the act of the Congress which prohibited a citizen from holding or owning property of this kind in the territory of the United States of America is not warranted by the Constitution and is therefore void. The second case we will be discussing is Plessy versus Ferguson of 1896. Plessy, the petitioner, was a citizen of the United States and resident of the state of Louisiana. He was of a mixed descent in the proportions of 7/8 Caucasian and 1/8 African blood. The mixture of color blood was not discernible in him. One fine day, he purchased a first-class railway ticket to travel to Covington. Within the same state thereafter, he took possession of a vacant seat in a coach where passengers of the white race were accommodated. The petitioner was required by the conductor, under the penalty of ejection from the said train and imprisonment, to vacate the said coach meant for white and take a seat in a coach assigned for people not of the white race. This behavior was based on an act that was passed by the state of Louisiana, providing for separate railway carriages for the white and the colored races. The petitioner refused to vacate the seat and thereafter was forcibly ejected out and imprisoned. The petitioner was brought before the court for the commencement of the trial. After the trial, the judge refused to give heed to his arguments. Plessy sought a writ of prohibition against the said judge. The court essentially considered the constitutionality of the act that was passed by the Louisiana Assembly. The first section of the said statute provided, and I quote, "All railway companies carrying passengers in their coaches in the state shall provide equal but separate accommodations for the white and the colored races by providing 2 or more passenger coaches for each passenger train, or by dividing the passenger coaches by a partition so as to secure a separate accommodation. No person or persons shall be permitted to occupy seats in coaches other than the one assigned to them on account of the race they belong to." The court said that slavery implies involuntary servitude, that is, a state of bondage, the ownership of mankind as a chattel, and the absence of legal right to the disposal of his own person, property, and services. The court said that what happened with Plessy did not tag him with the badge of slavery. It is an ordinary civil injury cognizable by the laws of the state. A mere legal distinction between the races, which is the white and the colored races, has no tendency to destroy the legal equality of the two races. Interstate commerce may still be governed directly by the federal statute. However, for intrastate commerce, which is what Plessy was doing in this case, states do have some freedom, which of course must be utilized in a reasonable manner. The court said that the enforced separation of races as applied to the internal commerce of the state neither abridges the privileges or immunities of the colored man, or deprive him of his property without the due process of law, nor does it deny him of equal protection of the laws within the meaning of the 14th Amendment. Every exercise of power must be reasonable and extended only to such laws as are enacted in good faith for the promotion of public good and not for the annoyance or oppression of a particular class. Then the question was, is the Louisiana legislation reasonable? The court answered this question in affirmative and in effect laid the foundation for separate but equal treatment of Negroes. The next document is the American Civil Rights Movement, which happened from 1954 to 1968. This movement was initiated by the United States of America's African Americans to protest against the racial segregation and discrimination against them. It involved various non-violent protest and civil disobedience movements to seek equal protection of both the state and the federal laws for the Black Americans. This movement was centered on the leadership and the philosophy of Martin Luther King Jr., who in 1964 won the Nobel Peace Prize for his role in this movement. The next case of relevance which we shall discuss is Brown versus Board of Education, 1954. This was a class action suit that was filed against the Board of Education of City of Kansas. This Board of Education operated a separate elementary school under a Kansas law which permitted districts to maintain separate school facilities for black and the white students. The plaintiffs were 13 parents on behalf of their children who were residing in this region. Plaintiffs petitioned for the Board of Education to reverse its policy on racial segregation. The court held that the question presented in these cases must be determined not on the basis of conditions existing when the 14th Amendment was adopted, but in the light of full development of public education and its present place in American life throughout the nation. In this regard, the court noted that education is perhaps the most important function of the state. It is the very foundation of a person's life. This must be made available to all citizens on equal terms. The court also relied in large part on those qualities which are incapable of objective measurement, but which make for the greatness in a school, that is, ability to study, engage in discussions, and exchange views. A sense of inferiority affects the motivation of a child to learn. Segregation with the sanction of law, therefore, has a tendency to slow, or let's say to retard, the educational and mental development of a Negro children, to deprive them of the benefits that they would receive in the racially integrated school system. Based on the foregoing, it was held that in the field of public education, the doctrine of separate but equal, which we discussed in the last case, has no place, and therefore separate educational facilities are inherently unequal. Now we shall discuss the evolution in Europe. First, the position in France. The first document we shall look at is the Declaration of Rights of Man and of the Citizen, 1789. In 1789, France's National Constituent Assembly in August passed the Declaration of the Rights of Man and the Citizen. Now, this declaration served as a fundamental document of the French Revolution and in the history of human and civil rights movement there. The declaration was influenced from Thomas Jefferson, who played a significant role in drafting the United States Declaration of Independence 1776, which we just discussed, and the doctrine of natural rights. Throughout this document, the people of France brought the abolishment of absolute monarchy and set the stage for the establishment of the First French Republic. This Declaration of the Rights of Man and the Citizen sees law as an expression of the general will and speaks about its formation through the representatives of the people. This declaration establishes the basic human right of treating all men as equal and free. The declaration calls for destruction of aristocratic privileges by proclaiming an end to feudalism and to exemptions from taxation and preservation of the rights to liberty, property, security, and resistance to oppression. This also prescribes rights of the accused and responsibility of the state in dealing with such situations. However, through this declaration, only a few men received the political rights, and they were called the active citizens. The passive citizens, on the other hand, included women, slaves, children, and foreigners who were deprived of their political rights. Women, in particular, were strong passive citizens who played a significant role in the French Revolution. Also, the declaration did not revoke the must-establish institution of slavery. The next document is Declaration of the Rights of Man and Citizen of the year 1793. Please note that this document was never officially adopted. This is the second and the lengthier declaration, and it was titled as the Declaration of Rights of Man and Citizen of 1793. But as I said, it was never formally adopted. The difference between this and the previous declaration is the egalitarian tendency. The 1793 version included new rights for citizens, including that to work. However, this marked a new beginning for social rights based on citizenship. It was said that a lot more will be done for the real emancipation and true progress of the lower classes. The next event, which is the Holocaust, when during 1941 to 1945 the Jews were being systematically killed all over Europe, the reaction of the local people was questionable. The Declaration of the Rights of Man and Citizen of 1789 in Article 3 specifically stated, and I quote, "The principle of all sovereignty resides essentially in the nation. Nobody nor an individual may exercise any authority which does not proceed directly from the nation." It is the first instrument that enumerates the rights of man. First instrument which, instead of criticizing a government or the state, listed out the rights of its citizens. Next, we shall be looking at the position in Poland and Italy. Now, taking lessons from the French Declaration, the Italian and the Polish position on the rights was that even though the individual is sacred, without placing the nation state first among aims, through whatever means, individuals can have no name, token, voice or right. As a result, rights were impossible to free from a nation state theory, as rulers were still worried about revolutionary access. Rights of a man were treated as a sort of stepchild in the 19th century. With this, we end part 1 of the historical evolution of human rights law. We shall continue with this in part 2. Thank you for listening.